I suppose there's a first time for everything, even for a retired litigator who thought he'd seen every kind of crazy across 35 years of courtroom warfare. But never, in all my years of legal brawls, did I expect my so-called golden retirement, meant for quiet mornings and the occasional tractor ride across my 100-acre Florida ranch, to be interrupted by process servers and pink surveyors taped tied to my front gate like some passive-aggressive gift. Enter Brenda Mulch, president of the Whispering Pines Estates Homeowners Association. A woman who viewed her HOA title not as a civic responsibility, but as a kind of self-appointed feudal lordship, one she seemed to believe extended as far as her gaze could stretch. Drop a comment below and tell me where you're tuning in from, because you're going to want to hear how Brenda tried to sue me for access to my private property, blissfully unaware that I'm someone who once ate lawsuits for breakfast. Now let's set the scene. My land is old Florida. 3 generations of Hendersons have called it home. It's a stretch of pine woods, oaks, and wilderness, bordering a nature preserve on one side, and unfortunately the surgically landscaped microyards of Whispering Pines on the other. Critically, my land is not and never has been part of Whispering Pines. The property lines are clear, recorded, and legally uncontested since my grandfather bought this spread back when cattle and scrub dominated the horizon. I retired here for peace, wanted to trade the hum of courtroom fluorescence for the rustle of palmetto fronds and the smell of sun-baked pine. And for 2 blissful years I had exactly that. Then came Brenda. The first warning sign was subtle, almost funny. A new entrance sign appeared at the front of Whispering Pines, a faux stone monstrosity with gold-painted plastic lettering that read Whispering Pines Estates, an exclusive community. And beneath it? President Brenda Mulch, her name damn near as big as the developments itself. I laughed. Thought it was harmless ego. Reader, it was not harmless. Ego mixed with power and total legal ignorance? That's a recipe for chaos. Our first direct encounter came one clear Saturday morning. I was on my tractor fixing up a section of fence near the Whispering Pines border. A border clearly defined by a decades-old, well-maintained barbed wire fence on my side, and a flimsy white PVC one on theirs, set a good 10 feet back. That's when I saw her. Brenda. Marching down the common path like she was storming the Bastille. Clipboard in hand, visor perched atop a helmet of sprayed blonde hair, and dressed in what I can only describe as weaponized leisure wear, a tennis skirt blindingly white, a highlighter yellow polo, and a Cadillac Escalade parked just shy of the dirt. "Excuse me," she called, voice sharp enough to shave bark off a pine tree. "You there? On the tractor?" I killed the engine and raised a brow. "Morning," I said, tipping my cap. "I'm Brenda Mulch, president of the Whispering Pines Homeowners Association," she announced with the tone of someone expecting applause. "I need to inform you that the association will require access through this section of your land." She said land, like it was something unpleasant she'd stepped in. I blinked. "Access? For what exactly?" She straightened proudly. "We're enhancing our community nature trail. It will run along the boundary here and we'll need to clear some of this." She waved a hand vaguely at the palmettos and sawgrass on my side of the fence. "This undergrowth. And of course we'll need to verify the boundary markers are up to HOA standards." I gave her a long look. "Miss Mulch," I said slowly, "with all due respect, this is private property. It's not part of Whispering Pines. My markers are accurate. And I'm quite fond of my undergrowth. That's called nature." Her smile flattened into a thin, brittle line. "Perhaps you misunderstand," she said, voice tight. "The community has decided this is necessary, for the beautification and utility of Whispering Pines. We have a right to ensure adjoining properties don't negatively impact our aesthetics or property values." "Our right, was it?" That was a new one. I raised an eyebrow. "I'm not aware of any such right, Miss Mulch," I said evenly. "My deed certainly doesn't mention granting your HOA access for trail construction or aesthetic enforcement. My property line is clearly marked by this fence, which I'll remind you is on my land. Whispering Pines ends about 10 feet that way." I pointed toward her immaculate Escalade, parked just short of the dirt. She didn't miss a beat. "The preliminary surveys conducted by our landscaping committee suggest an easement," she countered, her voice climbing half an octave. It was the kind of vague, official-sounding claim people make when they're wildly out of their depth but hope to win by sheer confidence alone. "An easement?" I asked, my inner litigator perking up. "Would you mind providing a copy of that recorded easement? I review my property documents annually, and I've never come across such a thing." I kept my tone polite, almost helpful. The best way to deal with a bluffer is to let them bluff themselves into a corner. Her eyes flickered. "It's being finalized," she said stiffly. but the intent is clear. The HOA requires access. Well, I said, stepping down from the tractor, until such time as a legally binding document appears granting your HOA any rights to my land, and I assure you no such document exists, access is denied. This is private property. And at this moment, Miss Mulch, you're trespassing. Your HOA's fence line is a good 10 feet behind you. Her face turned an alarming shade of puce. This is an unacceptable impediment to community progress. You'll be hearing from our legal counsel, she barked, hugging her clipboard like a Kevlar shield. I look forward to it, I replied with a calm smile I knew would drive her up the wall. Always happy to discuss property law. Now, if you'll excuse me, I've got fences to mend. I turned my back to her and climbed back onto the tractor. Behind me, I heard an indignant huff, followed by the retreat of footsteps and the crunch of gravel, no doubt as she veered too close to the actual property line. A few moments later, her Escalade roared to life and tore off in a cloud of dust, which settled quite poetically on her side of the fence. I shook my head, a grim little smile tugging at the corner of my mouth. Legal counsel, I muttered. She has no idea. I spent the rest of the morning repairing the fence, but part of my mind was already firing on old cylinders, statutes and case law snapping into focus like I was back in court. So much for a quiet retirement. Brenda Mulch had just declared war. And she was hilariously, catastrophically unprepared. The first official shot came a week later. Not from any high-powered firm as she had so dramatically promised, but in the form of a letter, on impressively thick cream-colored cardstock bearing the Whispering Pines Estates HOA letterhead. And, of course, prominently displaying President Brenda Mulch in oversized script. The letter informed me that I was in violation of HOA Bylaw 7, Section 3, Paragraph A, maintenance of adjoining properties and view corridors. It demanded I immediately cease obstructing the historic view corridor, a corridor I'm fairly certain she made up that morning over a latte, and grant access for the approved nature trail extension. Failure to comply within 14 days, it warned, would result in fines of $100 per day, legal action, and all other remedies available to the association. I read it twice, then let out a low chuckle. This was amateur hour, wrapped in self-importance and sealed with delusion. Where to begin? First, my property isn't in Whispering Pines. Second, even if it were, her bylaw didn't magically create easements or grant rights over private, non-member land. Third, an HOA can only fine its own members. I briefly felt bad for the poor souls who had to live under Brenda's thumb. Almost. Then I remembered the tennis skirt, the clipboard, and the sheer gall, and the pity vanished. Brenda wanted a fight? She was going to get one. It turned out that her first letter was merely a warm-up act. My calm, legally airtight response, complete with a copy of my deed, a highlighted plat map, and a firm reminder that my property wasn't governed by Narnia or the Whispering Pines HOA, only seemed to fan the flames of her indignation. A second letter followed. This one was even more arrogant. It accused me of unneighborly conduct and willful disregard for community harmony. The daily fine had now been bumped up to $150, retroactively no less. Attached was a sketch, clearly done by Brenda herself, in a moment of strategic brilliance. A dotted line meandered across a large swath of my back 40, labeled Proposed Nature Wellness Trail, Phase 1. It was less a legal document and more a fever dream rendered in ballpoint pen and pastel highlighters. She was, in essence, trying to annex my land with a crayon and a strongly worded letter. That's when I decided it was time to go on offense. Step 1. Reacquaint myself with the Whispering Pines Estates CCRs, covenants, conditions, and restrictions. Not because they applied to me but because knowing the rules Brenda was supposed to be following would prove useful. A quick trip to the county recorder's office and a modest fee later, I had a certified copy in hand. Reading them was an exercise in absurdity, regulations on everything from mailbox hues to garden gnome height. It was a tyrant's charter, and Brenda seemed to be its most enthusiastic enforcer. But more importantly, the CCRs made it abundantly clear. No authority to build trails on non-member property. No right to levy fines against outsiders. No power to create view corridors beyond HOA boundaries. Brenda wasn't just overreaching, she was operating entirely outside her own rules. Even if I had been a member, she would still be dead wrong. Soon after, I took a quiet stroll around the perimeter of Whispering Pines, sticking to public paths. I noted the perfectly mowed lawns, identical mailboxes, and that faint aura of architectural despair. A few wary residents gave me side eyes. One older gentleman pruning his roses, Mr. Henderson, ironically no relation, looked up and gave a faint nod. If he only knew what storm was about to roll in. He looked like a man who'd seen a few things. After introducing myself as the neighbor on the ranch side, I casually asked about the HOA. At first, his expression was guarded, but it softened a little. "Ah," he said, his voice low. "You're the one President Mulch is tangling with." I gave a rueful nod. "So it seems. She's got some ambitious plans for a nature trail." Mr. Henderson, no relation, ironically, snorted. "Nature trail? More like Brenda's stroll of superiority. Most of us just want the grass cut and the pool clean. But she always needs a project. Last year it was replacing all the perfectly good street signs, with new ones that had her name on them. Cost a fortune. Gold. Absolute gold. Does she often, let's say, interpret the rules creatively?" I asked, careful not to sound too leading. He leaned in, conspiratorially. "Creatively? Son, she rewrites the rules in her head as she goes. Half the folks around here are too scared to say boo to her. Get on her bad side and suddenly your prized petunias are a threat to community values, and you're neck deep in violation notices. Has she ever tried to claim authority over things clearly outside the HOA before?" He thought for a moment. "Well, there was the drainage ditch incident. She tried to tell the county to reroute it because it spoiled the view from her lanai. They just laughed. She didn't take that well. That sealed it. Brenda wasn't a one-off headache, she was a pattern. A petty tyrant in pastel leisurewear, emboldened by ignorance and surrounded by enablers too indifferent or intimidated to push back. It wasn't just my land she wanted, it was obedience. I decided to bolster my position. I quietly installed a couple of high-resolution security cameras. Nothing flashy, just enough to monitor the contested fence line and the back access gate. I had a gut feeling Brenda's next move wouldn't just be more nasty letters. Sure enough, a few evenings later, the cameras caught her in action. The Escalade pulled up, gleaming and obnoxious. Brenda climbed out, this time flanked by two men carrying post-hole diggers and a roll of the same pink surveyor tape I'd seen tied to my gate. They approached my fence. Brenda pointed dramatically into my property, then at the fence, then back again. One of the men stepped forward and rattled the gate. It didn't budge, locked of course. After a few minutes of agitated gesturing and increasingly animated conversation, they gave up and retreated. The footage was beautiful. Crystal clear. I labeled it Brenda's Folly, Exhibit A. Then the piece de resistance arrived by certified mail. The summons. Brenda, or more precisely the Whispering Pines Estates HOA, was officially suing me in county court. The claims? Trespass, ironically, nuisance for my unsightly natural vegetation, and a declaratory judgment demanding their historic right of access to build the nature trail. The attorney representing them was a name I vaguely recognized, Chad Worthington. Young. Overly enthusiastic. Better known for late-night TV ads than courtroom wins. Probably cheap, and easily swayed by someone like Brenda. I sat on my porch with the summons in hand, a warm breeze rustling the pines. And I laughed. Loudly. She'd really done it. She took her crayon map and her ego, wrapped it in delusion, and handed it to a lawyer who either didn't know better or didn't care. Either way, Brenda had gone from neighborhood nuisance to malicious litigant. "All right, Brenda," I muttered. "You want to play hardball in my old ballpark? Game on." I spent the next few days in my study, once my grandfather's office, still smelling faintly of old books and good bourbon, dusting off case law and precedent like I was back in the saddle. I didn't need a refresher, but old habits die hard. I drafted my formal answer to the complaint, a meticulous point-by-point takedown of every absurd allegation. I denied their claims with prejudice and asserted every relevant defense. Clear title, no recorded easement, no jurisdiction of the HOA over my property, and for good measure, abuse of process. I also began outlining a potential counterclaim for harassment and slander of title. Brenda had crossed the line. This was no longer just petty interference, it was legal intimidation, plain and simple. She was banking on the assumption that I, like most, would fold under the pressure of a court summons and mounting legal fees. She had no idea. She thought the guy on the tractor was some unkempt rube. She didn't know he used to eat this kind of case for breakfast. She was bringing a dull plastic knife to a gunfight and I was polishing the cannons. The answer I filed was a legal sledgehammer, densely written, thoroughly cited, and designed to make young Chad's eyes water. I didn't just refute their claims, I annihilated them. With actual statutes, certified county records, and legal precedent. Their fairy tale about view corridors and phantom easements crumbled under scrutiny. And just to twist the knife ever so politely, I included a final paragraph. I intended to seek sanctions against both the HOA and their counsel for filing a frivolous lawsuit, should they proceed. A professional courtesy. A shot across the bow. But Brenda wasn't the type to take hints. The lawsuit lumbered forward, fueled by her ego and Chad's growing stack of billable hours. Then came discovery. They served me with interrogatories, pages of generic questions and document requests, clearly designed to fish for anything remotely usable. My responses? Prompt, detailed, and utterly useless to their case. I provided my deed. A certified survey. The actual plat map. No fairy tales, no crayons. And I calmly reiterated, there is no easement. None exists. None has ever existed. Their fantasy trail was about to hit a very real brick wall. Things quickly descended from ridiculous to surreal. One interrogatory actually asked me to state all reasons why you object to the beautification of the community. I answered honestly. Plaintiff's proposed beautification requires trespassing on defendant's private property and destroying defendant's natural landscape. Defendant objects to trespass and the destruction of his property. It was like playing chess with a pigeon. It kicks over the pieces, poops on the board, and then struts around like it won. The real fun began when I sent my discovery requests. I asked for everything. HOA meeting minutes from the last 5 years, especially anything mentioning me or the nature trail. All correspondence about the dispute. Financial records showing board approval for legal expenses. Any surveys or expert reports used to justify their so-called easement. And my personal favorite, a list of all prior instances where the HOA had asserted rights over non-HOA property, and how those turned out. Oh, and I requested Brenda Mulch's deposition. Their response? Telling. It arrived late, incomplete, and full of boilerplate objections. Chad Worthington objected to almost everything as overly broad, unduly burdensome, or not reasonably calculated to lead to admissible evidence. Classic stonewalling, but in this case it screamed they had nothing. The meeting minutes they did cough up were redacted into uselessness. Vague references to Project Nightingale, apparently their covert code name for annexing my land, showed no substantive discussion or board vote to authorize litigation. It was a masterclass in how not to run an HOA. I filed a motion to compel. Judge Harrison, a no-nonsense jurist with more than a few HOA squabbles under his belt, granted it almost entirely. He ordered them to hand over the documents and schedule Brenda's deposition forthwith. I could practically hear Chad gulp when he called to negotiate a narrower scope. I declined. Politely. Meanwhile, my quiet investigation into Brenda's reign of incompetence continued. Mr. Henderson, my rose-tending informant, pointed me to someone far more valuable. Arthur Jenkins, a former HOA treasurer who had resigned a year earlier after clashing with Brenda. We met for coffee at a place well outside Whispering Pines. At first he was hesitant. But once I explained that I was a retired attorney trying to protect my land from Brenda's overreach, he opened up. Brenda runs that HOA like her personal petty cash drawer, he said, stirring his lukewarm latte. Board meetings are a joke. She pitches an idea like it's divine revelation, and anyone who questions it gets branded an obstructionist. He talked about her President's Discretionary Fund, a slush fund in all but name. New landscaping that just happened to be around her unit. Fact-finding trips to out-of-state garden expos. Nothing budgeted. No oversight. He hadn't kept documents, he was too ethical for that, but he gave me dates, agenda items, and keywords to request. More importantly, he gave me the smoking gun. The decision to sue me had been pushed through during an emergency session, with only 3 of 5 board members present. One of them was her loyal echo chamber, Carol, the HOA secretary who'd sooner eat her clipboard than disagree with Brenda. That violated their own bylaws. No quorum. No notice. No proper authorization. Now it wasn't just a flimsy lawsuit. It was illegitimate from the start. I sharpened my deposition questions accordingly. This wasn't just about land anymore. It was about exposing how Brenda wielded power like a petty monarch in yoga pants. If Whispering Pines residents knew she was burning their dues on unauthorized litigation, the HOA board would turn on her faster than a gopher in a lawnmower. The day of Brenda's deposition arrived. It was held in a sterile conference room at a court reporting agency downtown. I represented myself. No need to hire counsel for this. I was looking forward to it. Brenda swept in with Chad Worthington trailing behind, pale and twitchy. She wore a power suit that probably cost more than my first car and clutched a designer handbag like it contained nuclear codes. Chad kept fiddling with his tie. Brenda exuded the same smug confidence as someone who doesn't realize they've walked into a trap. I started calmly. Established the basics. Then I zeroed in. Ms. Mulch, I said, voice steady, can you explain the exact legal basis the HOA relies on to claim a right to build a nature trail on my private property? She launched into a scripted monologue about community benefit, harmony, and the heartfelt wishes of the residents. That's interesting, I interrupted smoothly. But I asked about the legal basis. Do you have a deed, easement, court order, or any binding document that grants your HOA this right? She looked to Chad, who stammered something about prescriptive rights and implied easements. Mr. Worthington, I said without breaking eye contact with Brenda, can you identify the specific dates and evidence of continuous, open and notorious use of my land by the HOA, for the full statutory period required to establish a prescriptive easement? He went quiet. My family has held this land without interruption for 70 years, I continued. There's been no such use. So if you do have evidence, I'd love to see it. Brenda jumped in. Our committee has conducted extensive research. Excellent, I said. Please provide the names of the committee members and copies of that research. She hesitated. It's an ad hoc committee. Mostly me. And a few concerned residents. Perfect. Her research was fiction. Her historic use was a fantasy. And her committee was just her and Carol playing HOA Mad Libs over Chardonnay. I moved on to the meeting where the lawsuit was supposedly authorized. Thanks to Arthur Jenkins, I already knew the answer. I asked for the date. Who was present? How the vote was recorded. Her answers became evasive. Contradictory. She insisted everything was above board. It wasn't. I had the bylaws. I had the quorum rules. I had the receipts. The seeds of her downfall were being planted, carefully, methodically, and with plenty of documentation. From the footage of her trespass attempt to the testimony of former board members, the case was no longer about a trail. It was about power. Abuse of it. Brenda Mulch thought she was grabbing a few feet of land. She was about to find out she'd ignited a legal bonfire, and she was standing in the middle of it holding the match. Brenda Mulch's deposition, to put it mildly, was a train wreck. Under oath, her sweeping pronouncements about historic rights and community mandates shriveled into vague recollections and baseless assumptions. When asked for actual dates, documents, or names of witnesses who could confirm the HOA's supposed historic use of my land, she'd either deflect, shoot panicked glances at Chad Worthington, who usually offered nothing of substance, or launch into rants about my uncooperative attitude. To anyone with even a passing familiarity with civil procedure, it was obvious her entire claim was built on bluster, entitlement, and fantasy. Even the court reporter, a seasoned professional, raised her eyebrows more than once at some of Brenda's more outlandish statements. A quiet, impartial signal that the room knew exactly how far out of her depth this woman was. But the real fireworks began when I turned to the lawsuit's authorization, or more accurately, the lack of it. I began, tone calm, almost casual. Ms. Mulch, let's talk about the internal HOA meeting where the decision to pursue legal action against me was made. According to your own bylaws, specifically Article 5, Section 2, you need a quorum of at least 3 board members for a binding vote. Correct. Brenda stiffened. We always follow procedure, Mr. Henderson. Excellent, I replied, flipping a page. Article 5, Section 4 also requires 7 days written notice to all board members before any meeting that involves legal expenditures over $5,000. Is that your understanding? Before she could speak, Chad blurted out, objection, relevance. Internal governance is not pertinent to the claims. Overruled, I said smoothly, mentally of course, but I noted his objection for the record. Please answer the question, Ms. Mulch. She bristled. I'm perfectly familiar with our bylaws. Then perhaps you can explain the meeting held on or about April 17th, the one where this lawsuit was allegedly approved. Who was present? She hesitated. Myself, obviously. Carol Withers, our secretary. And Bob Jenkins, I believe. I nodded slowly. You're certain Mr. Jenkins was present? Yes, she said a bit too quickly. He was involved in the discussion. Because my information suggests that Mr. Jenkins was on a Caribbean cruise at the time, and that his only involvement was a brief phone call that dropped repeatedly. Her face drained of color, then flushed red. Chad's pen was scribbling like mad. That's an outrageous allegation, she snapped. Bob was fully involved. So he was physically present? Participated in the full meeting and the vote. He participated. In person? She said nothing. And was proper written notice given to all 5 board members, specifically Mr. Armitage and Ms. Albright, 7 days prior to that meeting? Those were the 2 board members known to occasionally challenge Brenda's more imperial decrees. Silence. Brenda studied her nails like they held the answers. Chad cleared his throat again. We contend that procedures were substantially followed under emergency provisions, he offered weakly. Ah yes, I said with a touch of theatrical pause. The emergency provisions. Tell me, Ms. Mulch, what was the emergency? Was my peaceful pine grove threatening to self-combust and consume whispering pines in a botanical apocalypse? That did it? Brenda snapped. This is harassment. You're twisting everything. We have a right to protect our community, our property values. You're just an old hermit standing in the way of progress. I waited for her voice to drop from a shriek before replying evenly, Ms. Mulch, the only thing I'm obstructing is your illegal attempt to seize land you do not own. The only thing being harassed here is the truth, which, judging from this deposition, appears to be having a very hard time. Chad called for a break. They huddled in the hallway, voices low and frantic. When they returned, Brenda was sullen, giving clipped, one-word answers. The deposition ended shortly after. But it didn't matter. I had everything I needed. Her testimony, riddled with inconsistencies, admissions of bylaw violations and clear animus, was a gift. I added it to a growing stack of evidence. Damning HOA records redacted just enough to prove guilt and high-resolution footage of Brenda and her crew trying to cut through my gate. Next step, motion for summary judgment. This is the legal equivalent of calling game before the first inning ends. It means there are no real facts in dispute. Based on the law and the evidence, this entire case should be tossed out. The document I filed was thick, meticulous, and utterly devastating. Point by point, I dismantled their flimsy arguments. Trespass. They were the ones attempting to enter my land without permission. Nuisance. Native vegetation isn't a legal nuisance, especially to people who aren't even adjacent landowners. Declaratory easement? I attached county plats, a clean deed, and excerpts from Brenda's own deposition where she practically admitted no such easement existed. I also highlighted a critical issue. Their lawsuit was improperly authorized. No quorum. No valid vote. No notice. Which raised a serious question. Was the HOA even a proper plaintiff? And if not, was Chad Worthington authorized to act on their behalf at all? I didn't just ask the court to dismiss their case. I suggested it might be time for sanctions, against both the HOA and its counsel, for wasting everyone's time. Brenda thought she was bulldozing her way through a fence line. She had just walked into a buzzsaw made of law. That final section of my motion was designed not just to win a case, it was meant to get the attention of the other Whispering Pines board members. The ones who hadn't dialed in from the Caribbean. I made it count. I included an affidavit from Arthur Jenkins, the former treasurer, detailing standard HOA procedures and Brenda's long history of bypassing them. I also attached a running bill of my legal costs, meticulous and reasonable, and a newly sharpened warning about sanctions under Florida's frivolous litigation statute. This time I made it clear, I would be seeking them personally against Brenda Mulch as well as the HOA and its counsel. Their response was flimsy at best, a rehash of earlier nonsense and a limp attack on Arthur's credibility. Chad Worthington, for his part, now looked like a man deeply regretting his choice of client. The hearing was scheduled before Judge Harrison. The courtroom was quiet when our case was called. Brenda arrived, unsurprisingly, draped in another expensive, stern-looking suit, her jaw clenched with artificial confidence. But what was surprising were the 2 board members who followed behind her, Mr. Armitage and Ms. Albright. The very ones Brenda had kept in the dark during her emergency vote. They didn't sit near her. In fact, they looked like they'd rather be anywhere else. That alone told me everything I needed to know. When it was my turn, I rose and presented my argument without fanfare. Calm, factual, and relentless. I walked Judge Harrison through the deed, the plat maps, and Brenda's own damning deposition. I showed how the HOA had no legal basis. No easement, no authority, no justification. Your Honor, I concluded, this isn't a legal dispute. It's an abuse of the legal process, driven by the personal vendetta of an HOA president who thinks her authority extends beyond her subdivision's fence line. My client, I said that a few times for effect, though I was representing myself, simply wants to enjoy his land in peace. When Chad Worthington stood up to respond, it was clear his enthusiasm had waned. He stumbled through tired arguments about community interests and aesthetic impact, but even he didn't sound convinced. Judge Harrison leaned forward, steepling his fingers. "Mr. Worthington," he said, voice dry, "you're asking me to ignore decades of property law and recorded deeds, because Ms. Mulch doesn't like what she sees over the fence?" Brenda gasped. Chad stammered something about evolving community standards. The judge raised an eyebrow. "Counsel, an HOA is a legal entity governed by statute and contract. It does not have the power of eminent domain. Based on everything I've heard, this case is extraordinarily thin." He paused and turned his gaze, first to Brenda then to Armitage and Albright. "I trust the Whispering Pines HOA board is familiar with Florida Statute 57.105 regarding sanctions for frivolous litigation, and the potential personal liability of board members who approve such actions without a sound legal basis?" Armitage and Albright exchanged a panicked glance. Brenda looked like she'd swallowed a lemon. Judge Harrison didn't rule from the bench, but the writing was on the wall. As we exited the courtroom, Armitage and Albright made a beeline for me. Brenda, for once, stood alone. "Mr. Henderson," Armitage began, voice low and anxious, "we weren't fully aware of the details. Ms. Mulch assured us the legal basis was sound." I gave a neutral nod. "Gentlemen," Ms. Albright, "whether it was sound or not is now a matter for your board and your membership, who are funding this crusade." They didn't argue. They just nodded, subdued. The tide had turned, not just legally but inside Whispering Pines itself. Brenda's empire was cracking. And I didn't need to lift a finger. A week later, Judge Harrison issued his written ruling. It was surgical. Summary judgment granted. On every count. The lawsuit was dismissed with prejudice, meaning they couldn't refile. The opinion was laced with quiet judicial scorn. He noted the complete absence of any easement, the misapplication of nuisance law, and the HOA's blatant overreach. In a footnote, he acknowledged my sanctions request and explicitly stated he would retain jurisdiction to hear it, should I wish to proceed. It was total victory. I read the order from the comfort of my porch, a glass of aged whiskey in hand, the sun casting long gold rays through the pine trees. For the first time since this whole circus began, I felt the calm I'd moved here to find. But back in Whispering Pines, the real storm had just begun. Word spread quickly. Mr. Henderson, my quiet ally in rose cultivation, told me the next HOA meeting was standing room only. Armitage and Albright, newly motivated by their own potential exposure to sanctions, called the meeting themselves. Properly noticed this time. Brenda tried to hold her ground. She yelled. She cried. She accused everyone of betrayal. But no one bought it. The board voted, overwhelmingly, to remove her as president. Carol, her loyal secretary and echo chamber, resigned immediately. Chad Worthington, I later heard, was quietly dismissed as HOA counsel, his reputation charred by the brush fire Brenda had lit. Soon after, the new interim board reached out. Not to argue. To apologize. They issued a formal written apology on behalf of Whispering Pines and asked to settle my legal costs, an effort to avoid a public sanctions hearing. I was, shall we say, in a strong negotiating position. I didn't want to bankrupt the HOA. Most of the residents had no idea what Brenda had been doing in their name. But I did want to be made whole, for my time, my costs, and the sheer aggravation. We reached a fair settlement, full reimbursement of my legal expenses, a modest donation to the local County Parks Foundation, my suggestion to redirect their community beautification obsession, and a signed, recorded declaration affirming, explicitly, that no easement of any kind existed over my property. Case closed. Brenda Mulch faded from power. Her white Escalade, once a symbol of her control, now sat like a sad monument to hubris. There were whispers she was selling her unit. The Nature Wellness Trail, Phase 1 signs vanished overnight. The reign of Queen Brenda was over. Peace returned to the Pines. I went back to my quiet mornings, my slow walks, and the rhythm of a life well earned. The fences stood unchallenged. The palmettos thrived. Even the bird song seemed a little sweeter. Sometimes, when I'm out on the tractor near that far fence line, I half expect to see her stomping down the hill, clipboard in hand. But the path remains empty. Only the deer cross it now, cautious, unbothered, and free. I didn't win this battle with force. I won it with patience, preparation, and the kind of unshakable confidence that only comes from knowing the law is on your side. Brenda learned a hard lesson. Never underestimate the quiet man on the tractor. He just might be a retired attorney with a sharp mind, and all the time in the world to prove you wrong. What about you? Ever deal with an HOA president who thought they were royalty? Drop your war stories in the comments. And if you enjoyed this tale of suburban justice, like, subscribe, hit that bell, because you never know when the next battle might begin.